Have you ever thought about what would happen if the group fighting for your rights at work just up and vanished? Like poof, gone.
I don't think that's something most people think about every day.
I mean, could a union, the one that's supposed to be there at the bargaining table for you, just disappear? And what happens to their legal battles, especially if they're in the middle of a big fight against unfair labor practices?
Wow, that's a really interesting question.
It's like, imagine you and your coworkers finally win the right to form a union, a hard-won victory, but then right in the middle of a crucial legal case, the union dissolves. What happens to all that progress? Does it all just evaporate?
Yeah, that would be a huge blow.
Well, today we're diving deep into a Supreme Court case that tackles this very issue. It's all about the lifespan of a labor dispute when the union itself ceases to exist.
Sounds complicated.
It is, but it's also super important for anyone who cares about workers' rights.
Absolutely. Understanding these legal nuances can make a big difference.
So are you ready to unpack this legal puzzle?
I'm ready. Let's dive in.
Okay, so the case we're looking at today is New World International Development, Filigators, Inc., Stefan Stoss and Gül F. Ost versus New World Renaissance Hotel Labor Union. It has a really long title, but the core issue is fascinating. The Supreme Court decided this case on July 28, 2021, and it's officially recorded as GR No. 197889.
All right, so where do we even begin with this?
Well, let's rewind back to July 2002. That's when the New World Renaissance Hotel Labor Union scored a big win. They were officially certified as the sole bargaining agent for all the rank-and-file employees at the hotel.
That's a crucial step for any union.
Totally. This certification basically means they get to be the exclusive voice for all the workers in that group when it comes to negotiating a collective bargaining agreement, a CBA.
Right. The CBA is like the rule book for the relationship between the workers and the employer, covering things like wages, benefits, working conditions, all that.
Exactly. So getting certified is like winning the right to even sit at the negotiating table.
It's a fundamental right for workers to organize and have a say in their workplace.
Absolutely.
Yeah.
And in this case, the union, once certified, didn't waste any time. They submitted their first CBA proposal to the hotel in September 2002, outlining what they wanted for the workers. Then, they even amended the proposal in March 2003, showing they were serious about getting the negotiations going.
Makes sense. They wanted to get the ball rolling and secure better conditions for the employees.
Right, but it seems like the hotel wasn't exactly thrilled about this whole union thing.
Well, they didn't respond to either of those CBA proposals.
Really? Why not?
Their excuse was that there was this petition going around trying to cancel the union certification. It had been filed back in September 2002 by a hotel employee named DOLEPH and a bunch of other employees, like 197 of them.
So while the union is trying to negotiate for the workers, there's this internal challenge to their very existence.
Exactly. It's a messy situation.
Totally. So what happened with that petition?
Well, the Department of Labor and Employment National Capital Region, DOLE-NCR for short, looked into it and denied the petition in May 2003.
So it seemed like the union certification was safe.
You'd think so, right? But DOLEPH wasn't giving up. They appealed the decision to the Bureau of Labor Relations, the BLR.
Right.
The BLR also dismissed the appeal in December 2003, and that decision became final in January 2004. So at this point, both labor agencies had said, yep, the union is legit.
So you'd think the hotel would have to start negotiating with the union then, right?
What seems logical, right? 2 strikes and you're out.
But, of course, there's a but.
There's always a but, isn't there? In February 2004, DOP filed another legal challenge. This time, it was a petition for certiorari with the Court of Appeals, case number CAGR SP Num 82428. Basically, they were asking the court to review what the BLR had decided.
Ah, so this legal cloud was still hanging over the whole bargaining process.
Yeah.
But meanwhile, the union wasn't just sitting around waiting for this certification issue to be resolved.
No, they took action because the hotel was refusing to negotiate.
Right, so what did they do?
They filed an unfair labor practice complaint against the hotel. They argued that by not even considering their CBA proposals from September 2002 and March 2003, the hotel was breaking the law.
It's like a valid complaint.
It does, but the labor arbiter initially dismissed it in March 2004.
Why?
They said it was premature. The labor arbiter's view was that the union's claim of unfair labor practice wouldn't really be a solid claim until the Court of Appeals had made a final decision on the whole certification issue. So they were basically saying, hold your horses, Let's see what the higher court says first.
Okay, so the legal system was in a bit of a waiting game.
Yeah, it was. Then, in November 2004, the union tried to push things forward. They submitted a third amended CBA proposal to the hotel, and this time they specifically told the hotel that the BLR's decision affirming their certification had become final back in January 2004.
It sounds like they were saying, look, the lower courts have spoken, it's time to negotiate.
Exactly. They were trying to remove any doubt about their legitimacy. But guess what? The hotel, even after being told all this, still refused to negotiate.
Really? What was their excuse this time?
They said the Court of Appeals case was still pending. But get this, the Court of Appeals had actually already dismissed DADAP's petition in November 2004.
So the hotel's excuse was invalid.
It was. Even though they might not have officially received the dismissal notice yet, the legal basis for their refusal was gone.
It sounds like they weren't negotiating in good faith.
It does raise some questions about their intentions, doesn't it?
It definitely does. Now, on top of all this back and forth about bargaining, the union also claimed that the hotel was discriminating against some of their key officers.
Yes, that's another layer to this already complicated situation.
So what kind of discrimination are we talking about here?
Well, the union said that 3 of their officers, Joselito Santillana, Ramil Elnar, and Norberto de Villa, were basically demoted.
How so?
Santillana, who was a receiving clerk, got moved to the position of bellman. Elnar and de Villa, who were public area attendants, were transferred to steward positions.
Were their salaries or benefits reduced?
It's not directly. The union acknowledged that their basic pay and benefits stayed the same. However, they pointed out that after these transfers, the hotel hired casual employees to do the tasks that these officers used to handle.
So, the union saw this as a way to undermine their leadership and maybe even discourage other employees from supporting the union.
Exactly. They saw it as a tactic to weaken the union's influence.
It's a classic concern in labor disputes. When union leaders are targeted, it can send a chilling message to the entire workforce.
Absolutely. It can create fear and discourage people from speaking up for their rights. So, with all this going on, the union decided to revive their unfair labor practice complaint against the hotel.
This is the complaint that was initially dismissed as premature.
That's the one. They were now saying, look, we have a final decision from the BLR, the Court of Appeals dismissed the challenge, and the hotel is still refusing to bargain and is potentially discriminating against our leaders. This is unfair.
What did the hotel have to say in their defense?
They basically stuck to 2 main arguments. First, they insisted that their refusal to negotiate was totally justified because of all the legal back and forth about the union's certification. They said they were just being cautious and waiting for everything to be completely settled.
So, playing the waiting game.
Right. And second, about the transfers of those union officers, the hotel said it was just a normal management decision, exercising their right to run things efficiently. They claimed it wasn't about discrimination at all.
Just business, they probably said.
Pretty much.
So, the case went to the labor arbiter for a decision. What happened there?
The labor arbiter ruled in favor of the hotel in June 2008.
Really?
Yeah. They agreed that the hotel had a good reason not to negotiate because of the pending court case. And regarding the union officers, the labor arbiter said there wasn't enough proof of actual demotion since their pay and benefits hadn't changed.
Wow, so the union lost on both counts.
They did, and it didn't stop there. They appealed to the National Labor Relations Commission, the NLRC, but they lost again in March 2010.
So 2 losses in a row. It must have felt like an uphill battle for the union and the workers they were representing.
Definitely. But they didn't give up. They went to the Court of Appeals, hoping to overturn the NLRC's decision. This case was filed as CAGR SP number 116181.
What did they argue at the Court of Appeals?
They stressed that the hotel had no real reason to refuse to negotiate, especially after the BLR's decision in their favor became final. They pointed out that the Court of Appeals itself hadn't issued any order stopping that BLR decision from being enforced.
Sounds like they were making a strong case.
They were, and this time it worked. The Court of Appeals reversed the NLRC's ruling in March 2011. They said that a pending cancellation proceeding wasn't a valid reason to refuse to bargain, especially when the labor agencies had already sided with the union.
That's a big win for the union.
It was. The Court of Appeals even ordered the hotel to start CBA negotiations and to pay the union $50,000 in attorney's fees.
A victory for sure. But as we know, this legal saga isn't over yet. The hotel filed a motion for reconsideration.
They did. They kept arguing that the lower courts hadn't made any mistakes in their decisions. But then, in a supplemental motion, They introduced a whole new twist, the argument of mootness.
Mootness. What's that all about?
It's a legal term, but it essentially means the case is no longer relevant or needs a decision, and the reason they claimed it was moot was a real game changer. They presented evidence that the union had actually dissolved back in December 2005.
Wait, what? So years into this legal battle, the union that filed the complaint didn't even exist anymore.
That's right. They provided resolutions passed by the hotel's employees showing they had decided to dissolve the union. They even had letters sent to the BLR and to LLR NCR informing them about it.
That changes everything, doesn't it? How can you have a case about a union that doesn't exist?
It's a huge twist, but the Court of Appeals stuck to their decision. They said the hotel should have brought up the dissolution earlier, not at the last minute.
So they were basically saying, too little, too late.
Yeah, something like that. And that brings us to the Supreme Court. The hotel appealed one last time, and the Supreme Court had to decide. Had the case become moot because the union had dissolved?
This is the core question, the crux of the matter.
Absolutely.
So what did the Supreme Court decide?
The Supreme Court, in a decision written by Justice Lazaro Javier, sided with the hotel. They said the case was indeed moot.
So the union's dissolution really did change the whole game.
It did. The Supreme Court explained that a case becomes moot when there's no longer a real issue for them to decide on that would have any practical legal effect. They said that the union dissolving itself was a supervening event that made the whole unfair labor practice case moot.
Supervening event. That's an interesting term. What does it mean in this context?
It means something big happened after a judgment or during an appeal that changed the whole situation. It's so big that it makes the original judgment unfair or even impossible to carry out.
So the union dissolving itself was like a bombshell that changed everything.
Exactly. And remember how the Court of Appeals said the hotel waited too long to bring up the dissolution?
Yeah, they said it was too late.
Well, the Supreme Court disagreed. They said appellate courts can actually consider those big game-changing events, even if they're brought up late in the game. Their reasoning was that for a court to even have the authority to decide a case, there has to be a real party in interest, someone who would be directly affected by the decision.
And since the union didn't exist anymore, there was no real party in interest.
That's right. They said it would be pointless to make a decision about a union that was no longer there. Any decision, whether for or against the union, would be impossible to enforce.
It makes sense when you put it that way.
It does, right. The Supreme Court also addressed the union's argument that maybe they were pressured into dissolving.
Oh, so the union was saying they didn't dissolve voluntarily?
Yeah, they implied there might have been some coercion from the hotel, but the Supreme Court said that even if that were true, it didn't change the fact that the union was gone.
So they were focusing on the reality of the situation, not on the potential reasons behind it.
Exactly. And with that, the Supreme Court dismissed the union's unfair labor practice complaint. A legal battle that had dragged on for almost 2 decades came to an end, not with a bang, but with a whimper.
Wow. So what does all this mean for people listening who are in unions or might be facing labor disputes? What happens if their union dissolves? Do they lose all legal recourse?
That's the big question, isn't it? Does this ruling create a loophole for employers? Or is it just the logical consequence of an organization ceasing to exist? We want to hear your thoughts on this. Share your comments below and hit that favorite button if you found this deep dive into labor law insightful.
And before we wrap up, let's recap some of the key legal concepts that were at the heart of this Supreme Court decision.
Absolutely. First, we have mootness, which means a case is no longer relevant for a court to decide.
Second, we have supervening event, which is something major that happens after a judgment that can change the whole game.
And third, we have real party in interest, which means someone who's directly affected by a case. The court needs this for the case to even exist.
If you're fascinated by complex legal cases like this one, and you want to learn more about how they shape the Philippine legal landscape, then you need to subscribe to the deep dive.
That's right. Hit that subscribe button and join our community of informed listeners. We delve into crucial legal issues, breaking down complex topics so you can stay informed and understand the nuances of the law.
We'll see you in the next